Well, greetings. I am Tigress Sydney Acute McDaniel, the host of Evolve Weekly, the Ethical Gatekeeper. And I am coming live as committed, except 1 hour earlier on this day due to a prior commitment. Today, we will be talking about what I mentioned in a post on my platforms, both my political campaign platform and my personal professional platform as well. We're talking about why Diddy's attorney's public statement that the settlement is not an admission of guilt is all cap. We're also going to discuss, and I pause when I say discuss, because this will be my first time disclosing publicly the details of the child molestation that I experienced. That said, we will be discussing sex-related crimes and legislation. And of course, you will see how it is applicable to why Diddy's attorney's public statement that settlement is not an admission of guilt is all cap. We'll start with me because the world is talking about Diddy. I think we need to bring the issues back to the experience, suffering of the victim, the due respect that most victims do not enjoy, the solidarity, if you will, for victims who've experienced sex-related crimes that most victims do not enjoy. And when I say enjoy, I'm using the legal term enjoy. So it means similarly, of course, for lay people, if you will, or commonsensical, knowledge, or commonsensical conversation. But legally, it's a right that you should have this privilege. And I'm applying the constitutional laws to give the use of enjoy that legal connotation and that legal weight. You see, a victim, any person in general is entitled to enjoy what? Very simple, inalienable rights of what? Life, liberty, and the pursuit of happiness. Well, the liberty is taken away when a perpetrator, an attacker, assaults someone sexually. Life is taken away. Of course, arguably not literally so, but life is taken away because the quality of life is diminished when someone experiences sexual assault. And you'll notice that my demeanor is very likely different from most other days. I've been working up to this moment. And whereas I have no issue with discussing the matter, generally I've done so with more or less discomfort in private settings with people that are family members who I've learned that I cannot trust, and some that I can minimally trust. And otherwise, I feel the least discomfort when sharing my story with other victims, and for obvious reasons. When I was younger, my cousin, B. Roy Reed, molested me. Whereas there are some people in society that would look at his age at the time, which was over the age of 12, and actually over the age of 13. They would look at his age as that demonstrating a child, and thus would not attribute to him any liability for such wrongdoing, because they would say that he was engaging childish behavior, immature behavior, behavior that he could not fully understand psychologically was wrong. The law, however, does not agree with that thinking, that line of thought. It is best that we go ahead to the statute. I'm going to pull it up in real time. These, of course, are the North Carolina General Statutes. I have brought them to your attention on many occasions. Chapter 14 of the North Carolina General Statutes deals with criminal code. These are criminal laws. Criminal statutes, you've heard me explain the different legal jargon or legal terms that refer to crimes, right, or laws. So statutes are laws, legislation, laws, regulation generally, and policy, even at the municipal level, are effectually laws, right? Okay, for the sake of, general understanding. I'm sorry, I've gone past it. So 14, Article 26 deals with age and offenses against public morality and decency, which of course includes sexual or sex-related acts, sex-related crimes. So we're going to go to 14-178, which deals with incest. He was a family member, so therefore his sexual assault upon me constitutes incest. We'll go to 178. The offense. A person commits the offense of incest if the person engages in carnal intercourse with the person's grandparent or grandchild, parent or child or stepchild or legally adopted child, brother or sister of the half or whole blood, or uncle, aunt, nephew, or niece. Right. Punishment and sentencing. A person is guilty of a Class B1 felony if either of the following occurs. The person commits incest against a child under the age of 13 and the person is at least 12 years old and is at least 4 years older than the child when the incest occurred. The person commits incest against a child who is 13, 14, or 15 years old, and the person is at least 6 years older than the child when the incest occurred. A person is guilty of a Class C felony if the person commits incest against a child who is 13, 14, or 15, and the person is more than 4, but less than 6 years older than the child when the incest occurred. In all other cases of incest, the parties are guilty of a Class F felony. No liability for children under 16. No child under the age of 16 is liable under this section if the other person is at least 4 years older when the incest occurred. Okay. No child under the age of 16 is liable under this section if the other person is at least 4 years older when the incest occurred. So that's not the case here. Okay. We're going to go into it a little bit more. All right. Now, of course, the first statement that would, or the first argument, I'm going to approach this a little bit like I would if I were briefing a case, where you effectually prepare arguments for both sides and then you analyze the applicable legal doctrine or the governing doctrine, which just means that when I say doctrine, I'm talking about laws, case law, court opinions, things like that, Supreme Court opinions. And then you do your analysis, and of course you then make a conclusion whether or not there is a greater likelihood that there is a viable case. If you were doing this for your client, there you have it. Okay. In this case, again, the age or the element, and you've heard me mention this before. So for instance, if there is a crime, and let's go with the crime of, I've talked about this one before. Let's talk about the crime of, well, let's talk about this one. You know, I'm trying to be more clear, and instead I'll just use this one. This one has some tendencies to bring about some confusion, but you really just have to break it down very simply and stick to the facts, and law becomes immeasurably easy to understand. So just for the sake of you understanding what an element is, basically when you have a crime or a civil wrong, which is, it could be a tort, it doesn't necessarily have to be a tort, or you have a breach of contract, which is not a tort. So those are normally civil wrongs that you'll find in a business court, but they can also be raised in your general state tribunal, like your small claims court, district court, superior court. Okay. So generally something that you do that's wrong to someone else, an offense to someone else, that only entails civil liability, which means no jail time, right? And then you have a crime, right, which does entail or could entail jail time. In order for those to be prosecuted and for someone to be found liable over here for a civil wrong, and then found guilty over here for criminal wrong, all the elements for that crime or for that civil wrong must be met. Okay. And when they are met and the evidence is clear, and there are no mitigating circumstances, and there are no viable defenses for, no other viable defenses for the defendant, okay, the person who is having to answer the civil wrong or the criminal charges, then that is called a prima facie complaint, right? And that Latin term just means on its face, like it is what it is, okay? So when you're talking about the elements, let's say over here you have the crime of incest, because we're gonna stick with that. Now, of course, here it says a person commits the offense of incest if the person engages in carnal intercourse with the person. Okay, so that is one element. It basically means that every defining factor for a crime must be met generally for it to be prosecuted. Okay. And the same for civil wrong. If you don't meet all the elements, this is when the defendant's counsel can move to dismiss the case because it doesn't satisfy all the elements required by law to assign liability or guilt to a defendant. Okay. So in this case, the carnal intercourse was met. Okay. And let's see if we can bring up. I'm trying to share several screens. We may have to come back to it. Give me 1 second. Let's share the next screen. I'm going to leave that file up and hopefully it will allow me to. It's giving me the option for extra camera. I'm going to try. I'm not sure. No, that didn't work. So we're going to stop. Well, no, we're just going to keep using this one. We're just going to come out and we'll come back because it's pretty easy to do. All right. And we're going to come here. And we're going to look up carnal, legal definition for carnal intercourse. Carnal knowledge. Oh, well, that's not it. All right. Unlawful carnal intercourse means rape, incest, and unlawful carnal intercourse with a female, oh God, idiot, or what in the world is this? Or imbecile in contravention of Section 15 of the Immorality Act. Wow, that's very interesting. Okay. But intercourse between persons who are not married or are not partners in a customary union. Okay. And more likely, we're talking about when it, and we'll go into that further. But when you're talking about a female idiot or imbecile in contravention of Section 15 of the Immorality Act, which is actually what we'll go to really quickly so that we can get clarity there. I'm believing that it is talking about someone who lacks legal capacity, and that could be a child, okay? In its original form, this is what it has, right? Meaning a person with a mental disability. In 1988, it was amended to also apply to males. So the penalty was the same as that prescribed for violations of Section 14. And of course, it's immoral because that person would be without legal capacity to consent to the act, right? And then when you're talking about children, of course, that would also apply, that they are not of an age, legal capacity to consent to the act because they don't fully appreciate what is going on. But the older child who commits the act upon the younger child would be found with legal capacity sufficient to hold them liable and to, of course, appreciate what they're doing as wrong. Okay, so let's go back to here. And of course, just straightforward, it means rape or incest. Okay. And it doesn't necessarily mean penetration. Sexual intercourse means any penetration of the female sex organ by the male sex organ. Okay. So now let's go back. And we're going to go to 14 again. And as much as it seems like it's taken a long time, I guarantee you it will all make sense. Go back to 178. Okay. So you have the carnal intercourse with the person's grandparent or grandchild, parent or child or stepchild, or legally adopted child, brother or sister of the half or whole blood, or uncle, aunt, nephew, or niece. Okay. Okay. So, of course, B-Roy Reed is my first cousin. And that means that his mother is my mother's sister, and therefore my aunt, my maternal aunt. Okay. So based on this definition, then you would say, well, Tigress, then he is not guilty of the crime of incest. And you would be correct in applying the elements of the crime of incest and then analyzing whether or not all those elements are met. I brought you to this particular statute to discuss age. So now we're going to come back out. Offenses against public or morality and decency. And we're going to find in real time another statute and leading up to sex-related crimes or sexual exploitation or sexual assault. Okay. So here we are, still in chapter 14, because this again is the criminal code. So 14190, subsection 16, first degree sexual exploitation of a minor. The offense, a person commits the offense of first degree sexual exploitation of a minor if, knowing the character or content of the material or performance, he uses, employs, induces, coerces, encourages, or facilitates a minor to engage in or assist others to engage in sexual activity for a live performance or for the purpose of producing material that contains a visual representation depicting this activity, or permits a minor under his custody or control to engage in sexual activity for a live performance or for the purpose of producing material that contains a visual representation depicting this activity, or transports or finances the transportation of a minor through or across this state with the intent that the minor engage in sexual activity for a live performance or for the purpose of producing material that contains a visual representation depicting this activity, or records, photographs, films, develops, or duplicates for sale or pecuniary gain material that contains a visual representation depicting a minor engaged in sexual activity. Okay, so here, that list of the required factors, the required acts to constitute the offense of sexual exploitation, they're listed there. And those are then the elements for that crime. Of course, this does not apply in that the act of sexual assault upon me was not done for the purpose of recording it to show to others. Okay. So we're moving through and we're looking for we're getting there. Just hold on one second. All right, so we're going to go back up to 27 for rape and other sex offenses. Which is Article 7B. All right. You have all the definitions, which are very typically at the beginning of the article for obvious reasons. And this is why I emphasize over and over that it is important that you know the law of the land. And when I say know the law of the land, and when others say know the law of the land, what they're referring to is not just specifically the constitutional laws that like our federal laws that govern us all. You need to know, and so the land being the United States, you need to know the laws of the land for your state, your state of residence, your city of residence, your county of residence, because sometimes those regulations between the city and the county can be different. Very similar, and they won't contradict because they cannot contradict one another, and nor can they contradict state law, nor can they contradict prevailing federal law. But there can be some subtle nuances that are different. So you need to know the law of the land. All right. So a sex act, connubious, fellatio, analogous or anal intercourse, but does not include vaginal intercourse. Sexual act also means the penetration, however slight, by any object into the genital or anal opening of another person's body. It is an affirmative defense that the penetration was for accepted medical purposes. And of course, that makes sense. In my case, the sexual act was fellatio. So we're going to continue to go forward. So we see that by definition that it meets the element and definition of sexual intercourse or sexual act more specifically. And it also meets that for sexual contact, any of the following: touching the sexual organ. Of course, the vagina. Fellatio entails stimulating the vagina with one's mouth. And so touching the sexual organ, anus, breast, groin, or buttocks of any person. And that touching of another person, of course, is also defined. It means physical contact with another person. And of course, someone's mouth touching your private areas or someone's vagina. In my case, of course, that would constitute unlawful touching or constitute touching. And therefore, because it was not consensual, and I was a child and he was of age sufficient to legally hold him liable for his conduct, knowing that he could appreciate that it was wrong. There you have it. Okay, so all those things are met. All right. First degree forcible rape. A person is guilty of first degree forcible rape if the person engages in vaginal intercourse with another person by force and against the will of the other person and does any of the following. Okay, so we know immediately that this does not, and let's make sure Yes. Okay. So they are distinguishing intercourse from sexual contact and a sexual act. Okay. As you see here, fellatio, but does not include vaginal intercourse. Okay. So then we keep going. Second degree rape, again, these are all that which require vaginal intercourse to be a satisfied element in order to hold someone liable for rape. So we'll continue on. Then we'll go to first degree forcible sexual offense. A person is guilty of a first degree forcible sexual offense if the person engages in a sexual act with another person by force and against the will of the other person and does any of the following. Uses, threatens to use, or displays a dangerous or deadly weapon or an article which the other person reasonably believes to be a dangerous or deadly weapon, inflicts serious personal injury upon the victim or another person. The person commits the offense aided and abetted by one or more other persons. Any person who commits an offense defined in this section is guilty of a Class B1 felony. So then we go to second degree. A person is guilty of second degree forcible sexual offense if the person engages in a sexual act with another person by force and against the will of the other person, or who has a mental disability or who is mentally incapacitated or physically helpless, and the person performing the act knows or should reasonably know that the other person has a mental disability or is mentally incapacitated or physically helpless. Any person who commits the offense defined in this section is guilty of a Class C felony. We'll go to the next one in just 1 second. So the concern here is I believe that this could be arguably applicable, but it may be tough to fully prosecute this or successfully prosecute Bureau Reed for the crime of second degree forcible sexual offense, because I was asleep. And I know that I was asleep. Some of you maybe just continue on and listen to everything that occurred. It's a very difficult thing to have to share, but it is long overdue. Long overdue. Bureau Reed had a sister. And when I say had, I am inferring that she has passed away, and she did. She passed away about 3 years ago now, it seems. Dana Reed did have a mental incapacitation. This was something that was formally diagnosed in her adulthood, but not diagnosed when she was a child. B-Roy manipulated her to take me from the bed that I was sleeping, because my aunt wanted me and would have me sleep with my girl cousin, and for obvious reasons, and not sleep with my male cousin who was much older than me. And that makes perfect sense. But B-Roy manipulated Dana, his sister, his younger sister, to come and basically deliver me while I was sleeping to B-Roy's bed. So I was effectually physically helpless. And when I was younger, I slept extremely hard. Like I was not a light sleeper. And I just remember kind of like bits and pieces, the same recall that other victims have shared when they've experienced similar sexual trauma in their childhood, I just have like these kind of flashbacks, and I can't remember the entire assault in its entirety. I remember vaguely being picked up and not thinking any big deal of it because that was my cousin who I trusted and I was a child. And then I remember being delivered to Bureau's bed, and I remember that, you know, it was dark, and I remember feeling what he was doing and not understanding what was going on at all. So let's continue on, because arguably that could be applied, but also arguably it could not, because they could, depending on the definition that would satisfy the court for physically helpless. All right. So then we go on, and we are definitely doing this in 1 hour. It doesn't seem like it, but we are. 1427, statutory sexual offense with a child by an adult. Okay, a person is guilty of statutory sexual offense with a child by an adult if the person is at least 18 years old and engages in the sexual act with a victim who is a child under the age of 13. Okay, so he was not yet 18, so this would not apply. A person is guilty of first-degree statutory sexual offense if the person engages in a sexual act with a victim who is a child under the age of 13, and the defendant is at least 12 years old and is at least 4 years older than the victim. And this is where you work through all the elements, looking at the definition, if you will, the defining factors for the actionability of a crime. And then you find, and it's really just putting together puzzle pieces. And then you find the crimes that are applicable. And then that's how a prosecutor moves upon prosecuting and, you know, and bringing about charges and a bill of indictment and all the things, right? Okay. So let's just look at this one as well. Statutory sexual offense with a person who is 15 years of age or younger. A defendant is guilty of a Class B1 felony if the defendant engages in the sexual act with another person who is 15 years of age or younger, and the defendant is at least 12 years old and at least 6 years older than the person, except when the defendant is unlawfully married. So this would not apply, because our age difference at that time was not 6 years old. Okay. So basically we're looking at 14, 27, 29. Now, Tigress, what does this have to do with Diddy? And what does this have to do with Diddy and Cassie? And what does this have to do with the public statement that Diddy's attorney made, that his settlement is not an admission of guilt? Diddy was facing civil liability. He was not facing criminal liability. We know that because he settled in a civil complaint. He didn't take a plea bargain in a criminal complaint. All right. And I'm alluding to why his settlement is indeed an admission of guilt and prima facie, like on its face, when I mentioned the plea bargain for the criminal actionability of his sexual assault and sex crimes against Cassie. All right. So again, I am attempting to do my best at also emphasizing the due respect and the care that should be exercised for victims and that they should enjoy, because their inalienable rights have already been detrimentally violated. And most often, the trauma is lifelong. And thus, again, arguably, their inalienable right to life is deprived in many ways. Why am I discussing this? Why am I discussing this on this platform? Because mental health. Because generational curses in families of all different types of ethnic groups are too often very dismissive of sex crimes against children that happen within the family, whether it is incest, as we have defined, which would need to, of course, the element states that there must be this sexual intercourse that happens between parent, grandparent, nephew, niece, aunt, uncle, that immediate family. They're not considering the cousin to be part of that immediate family just for the sake of the legal definition. Because a maternal cousin, first cousin, is not a familial status that somehow absolves the perpetrator's acts upon their family member. And we have to stop that in the Black community. I've seen way too many Instagram reels that are full of comedic dismissiveness of sleeping, with your cousin as if it's okay amongst the Black community. I've seen it in our movies, and it is so offensive and it is so disrespectful. It is disrespectful to victims like myself. It is disrespectful to even ourselves as the diaspora. That we would think that it would be okay to engage this type of behavior, albeit consensually or otherwise, because we know that generally if there is a consent between two people who are of the same familial lineage as cousins, first cousins, second cousins, third cousins, there's nothing appropriate about that for them to decide that they're okay with sleeping with one another and having children, or just sleeping with each other just out of lust and self-indulgence. So much has remained unchecked for so many years, and too many years. Okay. And equally, we see that Diddy has unlawfully enjoyed being unchecked for his crimes against Cassie. And as the stories continue to come out, others as well. Okay. So then again, why do you say, Tigress, that his settlement is an admission of guilt? Well, most of you already understand the commonsensical application of what I'm talking about, but let me get into it with further detail. And let me come here. So let's stop the screen for a second here. All right. When one is facing criminal liability and they take a plea bargain we're going to liken as synonymous with a settlement agreement for the civil side. So plea bargain, criminal side; settlement, civil side. Make those equivalent. Okay. So that you understand this breakdown. The plea bargain on the criminal side Now, it validly can demonstrate no such admission of guilt. Like, it does not necessarily mean that there is an admission of guilt implied at all. We know this because very often in criminal proceedings, defendants, the ones who are facing criminal charges, are too often possessing insufficient knowledge on how to successfully or sufficiently, defend themselves, and they rely heavily upon their counsel. And in so doing, they also, driven by this fear and the explanation by their counsel with regards to what the crime, what punishment the crime or the criminal charges will entail, if that punishment is too great for that person and they fear it, then they may enter into a plea bargain, which very often, because that's the nature of a plea bargain, it's a plea and a bargain. And the bargain is for lesser punishment, lesser or less severe punishment. And so that is especially attractive to the person who does not have sufficient knowledge of the criminal law and criminal proceedings, and that's relying upon their counsel. Or if the evidence is so weighted unfavorably toward them, even if they didn't commit the crime, that it is in their best interest to enter into a plea bargain instead of being at the mercy of the jury and the judge, who will see the evidence as weighted unfavorably, against that defendant. So in those type of cases, yes, that validly is not an admission of guilt. A plea bargain in a criminal action is not necessarily an admission of guilt. I agree. Let's go to the civil side. When the attorney says, for Diddy, says, well, no, in this day and age, a settlement agreement and even the quickness of the settlement that Diddy agreed to is not an admission of guilt. Honey, that's all cap. Because let's come on over here. And the attorney knows that that's all cap. On the settlement side, there is no risk of being jailed unless he committed contempt of court, which would be separate and in addition to the claims in Cassie's complaint. Like if he failed to comply with some order during litigation, during the course of the trial. But that was not the case, because in a civil contempt matter, you can be detained by the court and you can be jailed by the court until you comply, until you come into compliance. But that's not the case here. So he was not at risk of any type of jail time. Okay. All right. At best, he would risk, yes, exposure, more exposure during discovery. And most of you already understand discovery, so I don't have to go into detail about that. It actually, the term is pretty self-explanatory. It's, the period during litigation whereby both sides present their evidence and then present it to the court, the judge, and argue its admissibility, to have it accepted on court record as evidence to use in the final trial or used in the conclusion of the matter, the adjudication of the matter, the deciding of the matter, right? In a case where in a civil case where, let's just use this as an example. There is a credit reporting agency, let's say TransUnion. TransUnion has somehow violated my rights as a consumer under the federal, under the Federal Fair Credit Reporting Act, right? Let's say that in that type of case, I have clear evidence, and clear evidence is typically that which can't be easily defended against, right? So I have clear evidence that TransUnion has definitely committed FCR violations. And let's say TransUnion contacts me and they're ready to settle. Let's just settle this out of court. Now, maybe there are some stipulations in law that give them just cause for having acted in the way that they did that only appears to be a violation of the FCRA. For instance, maybe I failed to give them time to handle my dispute. I sent the dispute, wanted them to take off this bad debt that's appearing on my credit, which is appearing there in error. I disputed with TransUnion on November 28th. We're just using the day, right? And then November 29th, the next day goes around and I go straight to court and I start my lawsuit. Where it's premature and I haven't, because I haven't given them an opportunity to follow the procedure in the FCRA that would actually be a defense for them against my lawsuit. But let's say they say, you know what, we're at the point where we know that we're going to spend upwards to $5,000 or $10,000 to employ our legal resources, our retain an attorney, or most often, of course, they have an attorney on retainer. And instead of that, it is in our best interest to go ahead and settle with you now. That is not necessarily an admission of guilt. That is when you're talking about a situation where the judicial economy is better served and the economic interest of both parties involved is better served through a settlement. When I say judicial economy, we're talking about the time, the caseload of the court and having to handle cases that are not as important as other cases, okay? However, in Diddy's case, we're not talking about judicial economy. We're talking about a case for which there can be both civil and criminal liability. Now, of course, the act that is applicable in New York, that for which the statute of limitations is about to expire, hasn't expired yet. And at least allows her to proceed, for, the civil liability side of it. Similarly, there is legislation in the state of North Carolina. And whereas I completely disagree with this type of legislation that bars a victim's recovery under a statute of limitations that's like 10 years or so, this has been kind of copycat legislation around the nation. And as a victim, I'll be honest with you, I believe that it's been done knowingly and unethically so, motivated by perpetrators who have influenced legislation, who do not want to be held liable for their acts in the past. And now, unfortunately, it has also served the greater public at large perpetrators who don't have the benefit of the good old boy system to also enjoy this protection, if you will, from criminal liability under these shortened or these short statute of limitations, very limited. So if judicial economy is not an issue in the civil case, there's no judicial economy issue here. Your case is significant, period. Your case, a case about civil liability for sexual assault, is definitely higher up on the list of priorities for the court than an FCRA violation complaint, where the plaintiff hasn't even allowed the case to become ripe. When I say ripe, basically think of ripeness the way you know it. It's not time. It's not time for me to take, action on this complaint and move forward and say, hey, they did wrong, because it was just yesterday. They haven't even had a chance to comply with the dispute procedures. Diddy's case is high up on legal priorities, so it would not entail an issue of judicial economy. It's not an issue at all. The economic interest of the parties is not an issue. Cassie's financially straight. In comparison to, lay people, hell yeah, she rich. She's been rich, right? She's had access. She's good in that regard financially. Or generally so, because we don't know, the full details, but we can infer that she's doing fine financially, especially in comparison to the rest of us, right? So her economic interests it's not an issue. She needn't rush, into the settlement agreement for the sake of, the cost that she's incurring from her attorney. I feel very strongly that her attorney, based on how her resolve was, and I don't know if it is a woman. I remember reading an article that she very likely took the case and agreed to be paid upon, the conclusion of the case. So no judicial economy issue, no economic interest issue on the part of Cassie. And we know there was no economic interest at issue for Diddy. Why do we know this? Because $30 million, I believe the man is worth, let's see, hold on. Diddy's net worth. All right, according to, oh good gosh, in 2007, according to Forbes magazine, in 2017, he had earned $130 million. Okay, but in 2022, his estimated net worth was $1 billion. Now we know that doesn't mean that he has liquidity of $1 billion, but still. So $30 million is a lot of money for, when you're considering liquidity, because he can't pay her $30 million in credit. He can't pay her $30 million in intellectual property. Not for this settlement agreement. When you're talking about a settlement payment, that's you giving that person cash. Of course, in the form of a check. or some wire transfer, that is highly regulated, all the things. So $30 million, that did entail an economic interest for him, for sure, but he's worth $1 billion. So $30 million was like a drop in the hat for him. So then he must, by straightforward analysis, have a greater interest in protecting himself against the risk of being exposed during discovery, which would then expose him to criminal liability. And even so, more aptly so, because they would have such detailed evidence and very likely clear, indefensible evidence of his criminal liability for very likely innumerable sex crimes upon very likely innumerable victims. So yes, there was an economic interest, kind of generally, like, okay, take, pay this, you're worth $1 billion, pay this $30 million. That's definitely going to take away from you economically. But is it going to deplete him? No. Is it going to bankrupt him? No. Is it going to, even if he just still had the $130 million, which would be more likely that he had that liquidity, if you will, he still wouldn't be bankrupt. He still would not, very likely not lose his standard of living that he's become accustomed to. So by process of elimination and simple deduction, we know then that his concern, his primary interest, was to evade being shown demonstrably that he was guilty of sex crimes, and not only liable for the civil wrong of his sexual acts upon Cassie. Y'all, it's straightforward. It's very straightforward. I'm a huge proponent for extending the statute of limitations. In my case, I can only, I can't speak for Cassie. Cassie is speaking for herself, and I'm definitely on the side of standing in solidarity with those who have been the victims of sex-related crimes. And giving them respect. Because you don't fully appreciate what a victim of a sex crime endures as they age. Even more so, you don't fully appreciate the trauma that a child experiences, like myself, when they are sexually violated and expected told to effectually get over it. Or such telling, such viewpoint of get over it is implied, so much so that a child believes that they're not allowed to talk about it. In my particular case, I told my mother. I was raised in a home that she wanted me to be open with her, and I appreciate that, because that, that gave me the safety to tell her. I remember there was a lot of conflict for quite some time between my mom and my maternal aunt, her sister, B-Roy's mom, B-Roy and Dana's mom. And I remember that I was at that point, after the incident, after the crime that was committed against me, my mother would not allow me to go and spend the night at their home anymore. Our relationship forever changed. And ironically enough, I remember over the years, my aunt, she would, with the irony is she became my closest aunt, and I had a better understanding of why as I got older, because of course there was her own self-guilt, and I believe she gravitated toward me because of the situation, in guilt, of course, and empathy, sympathy for me. And no one ever said, you can't talk about this, because I did talk about it. I'm very vocal. I talked about it amongst my trusted cousins, or so I thought, because my family has not given me the respect that I am due. They have continued upon the generational curse of not wanting to talk about things. And now, ironically, B-Roy has used the dismantling of my family, which happens in a lot of Black families and a lot of families in general of different ethnic backgrounds, where the matriarch passes away, who, is kind of the glue of the family, or not in my case, she was the glue of the family when she passed away. The family, the immediate branch, my first cousins, my immediate maternal aunts and uncles kind of, dismantled slowly but surely over time, to the point where in the last 5 to 10 years, I don't really have any relationship with them. And in my absence, and I say the relationship that I did have with them was very surface, even though I tried so often, too often, to rekindle our familiar relationship, because our family was such a beautiful thing when I was younger, the irony of it all. Now, keep in mind, because of the way that my mom addressed the matter, it helped. But then there are some hurts and trauma there as well, because even where she definitely stepped right in to protect me and to address my aunt and my cousin and get me out of that situation and keep me out of that situation, the fact that she didn't give the due respect and fullness to my voice as a victim and proceed upon criminal charges or give me that voice, that opportunity to confront my victim. I not ever had the opportunity. I was always still in the role as a child to respect my elders and to not be disrespectful. It was considered disrespectful to have certain conversations in their presence. So, and you all, a lot of you who are listening to this now, you fully understand what I've gone through. So can you imagine also what Cassie went through? Because she was the victim of a pattern and practice of sex crimes. For me, it was one and done, thankfully. And that still has translated into significant trauma into my adulthood that I am still to this day healing from. And especially as it relates to the way that my family has handled it. Again, as I stated, in my absence, I don't believe I completed my thought. Let me complete my thought there. In my absence during this dismantling of our family, I've learned recently in the last 3 weeks from one of my trusted cousins, or minimally trusted cousins, who's trying to remain neutral because she's learning that there's so many generational curses and secrets amongst our family, lies that she's been, told, led to believe. And she concealed that B-Roy has evidently convinced my first cousins that I am lying and that I have made the story all up. And they've even had, what I recently learned, they've even had family reunions, many family reunions in my absence, intentionally disinviting or uninviting me. And they have been pulling away, and now I understand. Pulling away from me, and now I understand. So that's another injury that he's inflicted upon me, because he is depriving me of the relationship with my family that I should have. Now, that may not necessarily constitute an actionable crime by law, but it definitely is an actionable offense when we're talking about humanity and family code. So, can't imagine what Cassie's going through. And I am glad to see that a lot of people are not being disrespectful toward Cassie during this time. And this brings me to the final statement that I want to make for this particular broadcast. The statute of limitations for these rape and sex-related crimes it cannot be shortened any further, and it needs to be extended. They've even similarly shortened the statute of limitations for fraud. Once upon a time, there was no statute of limitations for fraud. Once upon a time, there was no statute of limitations for many different types of criminal acts. Let me look here. For murder, even. For rape. For arson. No statute of limitations. But in my case, whereas you would perceive it to be rape, when we look at let's go back to the section and we'll conclude here. Share my screen. Oh, wait, sorry, I'm doing the wrong screen. All right. So we know that 14, we've decided, and looking at the elements, that 1427, subsection 28 applies. Statutory sexual offense with a child by an adult. All right. Okay. But statutory rape requires the element of vaginal intercourse be met. In my case, I do not recall whether or not B. Roy penetrated my vagina. And a part of me believes that if it did occur, because my hymen was not checked, I don't remember any of that. These were conversations I was not even allowed to have. My mom did not take me to a police officer. All these things could have been done. And I deserve to have those things done. And not having those things done on my behalf has definitely resulted in trauma, because I was effectually told, forced, albeit impliedly, to let it go and not talk about it. And of course, as a child, I don't know that I need to go and talk to the police. I don't know, I'm following the direction of my parent. I'm following the direction of my aunt. I'm following the direction of my elders, and believing that they have my best interest in mind. I'm relying upon them. I don't know that I need to have my hymen checked. I don't know if I need to, I don't know these things as a child. I don't know these things. So I believe that if it did occur, if B. Roy did commit non-consensual vaginal intercourse with me, that because I don't remember, I suppressed that memory due to the traumatizing nature of the entire act. And not only because I was in and out of sleep. And my cousins and my family knew that I was a hard sleeper as well. And then that's why I go back to that other, the proceeding, and I mean proceeding in this chapter. This is chapter 7B, or article 7B, rape and other sex offenses. I argue that I was physically helpless. And thus, let me pull it up. Yeah, and thus 1427 here, right here, 1427 subsection 27, second degree forcible sexual offense, arguably applies. But because I cannot remember, and I am a lawyer and I know how this goes, I would not be a reliable witness, even though the act happened to myself, because as a child and the trauma that I experienced and what parts of the incident that I can, this sexual attack on my person that I can remember, they will be very directly attacked by his counsel, whether he would hire an attorney or it would be a public defender, and there would be a great likelihood that the court would find that my testimony is only sufficient for statutory sexual offense with a child, under subsection 29. I'm sorry. Wait, let me go to it. My apologies. They would find that that my testimony would be only satisfying the elements for first degree statutory sexual offense, subsection 29. There's so much. There's so much. And so generally, let's go to, and we'll end it here because I believe we're at 120. The statute of limitations, it actually appears in chapter 1. So let's see here. And actually, give me 1 second. I'm going to pull up because this may be only for. All right, I'm trying to pull it up here. Yeah, generally for so the statutory sexual offense with a person, these typically there are certain legislative acts, and I'm actually going to link it so that you'll see. Generally, since rape and the vast majority of other sexual offenses, including indecent liberties with a minor, statutory rape, and statutory sex offenses are felonies, prosecutors do not have a time limit for pursuing these cases. Okay. For the civil lawsuit, generally for this is 1 to 3 years. And then you have a countdown when the child turns 18. In my case, I am 47 or will be 47 on December 5th. And then for child molestation or child sexual abuse, you have a 10-year statute of limitation that starts, when the child turns 18. So that, of course, would have expired severally. So the point that I'm making is that sometimes the trauma can be so deeply impactful and can destroy a family. And the irony is that victims often are left having to deal with that emotional and psychological damage and the weight of exposing the perpetrator, exposing the family member at the risk of losing their familiar relationship. Well, in my case, since my relationship with my family has been taken away from me, and ironically enough, by the same perpetrator, it is time to get justice. Long overdue. Oftentimes, victims, like in my situation, we are we are put in a situation where we have to decide between our own healing and justice and protecting the family from embarrassment. I choose me. I choose me. And if there are any victims out there within the reach of my voice, like Cassie, like myself, like many others who have come forward in their time, please understand, it's always after much deliberation. I want you to choose you as well. Do not wait a decade. Do not allow any of your family members or anyone who would suggest to you that you should just keep it secret and, that just staying away from the perpetrator will be sufficient enough for your healing. It is not. Choose you. Seek the professional psychological help that you can. Fully embrace healing. Do not quiet your voice. Speak up. Pursue criminal charges. Pursue civil justice as well. You deserve the civil justice. You deserve to not have to pay for your own healing, to pay for psychological well-being, literally from a licensed psychologist. You deserve to not have the burden of that bill. You deserve that. You deserve to not have the burden of protecting your family from embarrassment. Or from reality. You deserve that. Choose you. And I stand in solidarity with Cassie and all victims of sex-related crimes. I am Tigress Sydney Acute McDaniel, your host of Evolve Weekly, the Ethical Gatekeeper. Join me next week. Same time, same place. Well, actually not same time. I will be going, let me give you that update. I will have a guest. And it will be at earlier in the day. We're actually going to pre-record, and then it will air at 7:00 on my YouTube channel. So thank you for listening. Thank you for tuning in. Thank you to those who watched me live today, and thank you to those who will watch in the future. Again, Tigress Sydney Acute McDaniel. This has been another broadcast of Evolve Weekly, the Ethical Gatekeeper.